Hi, I'm Dan Thompson, partner at Goyette, Ruano Thompson. We're talking today about an issue that is one of the most pressing and hot-button topics in the California workplace, that of COVID-19 and related mandates that are impacting not just you as employees, but also your employers. It's important to understand that the ultimate responsibility for imposing regulations rests squarely within each individual state. California is certainly no exception, and as we sit here today, we are dealing with a wide variety of mandates, whether they're coming down from the governor's office, the Department of Public Health, or even more locally at the city, county, and private employer level. So what does this mean for you as an employee? You come to work one day and all of a sudden your employer is requiring you to sign a piece of paper or even more significantly, get a vaccine. These are some of the biggest questions that our office is currently tackling on a daily basis. And let's break those down individually. The first pertains to whether or not you're being required to disclose your vaccination status. The second being whether you choose to deny to disclose your status or you simply say that you aren't vaccinated, what are the consequences? What can your employer require you to do? And then the big elephant in the room, what happens when they say you've either got to get a vaccine or perhaps lose your job? Let's talk about the first question that comes up the most often, and that is whether or not an employer has the right to ask you to disclose your vaccine status. Whether that be you're signing a form saying that you are or are not vaccinated, or whether they're just asking you verbally. Even before COVID existed, regulatory agencies in the state of California gave employers the right to do this. And why is that? Because employers have a vested interest in ensuring that the health of their workforce does not impact their business interests. Now, also understand, you as the employee have the right not to disclose your vaccination status, but if you choose to do this, there is an automatic consequence. You will be identified as someone who is unvaccinated. Well, what does that mean? That means that you might, in fact, be subjected to certain protections and requirements within the workplace, such as wearing a mask, testing regularly, social distancing, or even telecommuting, if that's an option within your particular employer's scope of business. So let's assume that you're not vaccinated, or you decline to provide your status and you're automatically considered to be such. Can your employer require you to test twice a week, to wear a mask, to socially distance? And the short answer is that yes, they can. And why is that? Because the regulatory agencies again have said that if it is job related and necessary to the business, the employer who has an interest in that business may require you to do that. Obviously, employers have an interest in keeping their employees healthy. They don't want their clients to become sick. They don't want their job productions to fall. So if they believe that it is important to keep that preserved, they can ask you to test and wear a mask. Now, one important thing to bear in mind, when your employer comes to you and has a conversation about your vaccination status, the most that they can get out of you is a yes or no answer. They cannot get into your health history, your rationale, your thinking, or your reasoning behind why you are or are not vaccinated. That is all clearly protected private health information, and keep in mind so they don't take advantage of you in that way. The most controversial question that we are now receiving, especially on the heels of the FDA approval of the Pfizer vaccine this week, is whether or not an employer can legally mandate you as a condition of employment to receive the shot. Currently in the state of California, our regulatory and legislative bodies are in full support that vaccines can and should be mandated. So it comes down to each individual employer to decide how they want to proceed. Well, what if you as an employee say, I'm not going to take it, that's not my responsibility, and you don't have the right to tell me otherwise? That is going to be an issue that needs to be resolved either by the legislature or our court system. As we sit here today, there are no court decisions in the state of California that give us an answer one way or the other. There are some that are currently pending, but they have not as of yet been decided. So if we look at what the court decisions have shown us around the country thus far, fortunately or unfortunately, the trend has consistently been that the courts are saying that if the state mandates vaccines, and by extension so does your employer, that they can and will support that. Even if your employer mandates that you must take a vaccine to work there, there are exceptions. And they fall both under a medical exception and also under a religious exception. Okay, let's break each of these down. We have both the medical and the religious exemption. What does this mean for you and how do you apply for and qualify for each? Let's talk about the medical exemption first. You need to provide a statement in writing to your employer that says that you are submitting for and qualify for a medical exemption. Well, how do you prove that? It needs to also be accompanied with a doctor's note by a qualified medical professional that is treating you as their patient. All it needs to say is that in their professional judgment, you do qualify for and should receive a medical exemption from receiving the vaccine. That should not go into any of the details of your personal health history. That is all protected and private. Once you submit that to your employer, it is important that they then meet with you to discuss it further. All right, let's talk about the religious exemption. As you might imagine, this one's a little bit more tricky because religion is not something that you can define in a box. It is unique to each individual and it is personally held. So the employer cannot inquire or question whether or not your religion is even valid. It doesn't matter if they don't believe you that it exists or is real. However, what they can do is they can question whether or not your religious beliefs under that religion are sincerely held. Well, what does that look like? How do you define that? And that's a difficult question to answer because it's unique to each employee. When you submit your request for a religious exemption, you should do so with as much detail as possible. If you have religious leaders, religious texts, or other guidance through your particular religious organization, it's important that you state those things to back up your reasons for why you need a religious exemption. Now, even though you as the employee can provide those things, your employer cannot ask you for them. They cannot ask you for a signed document from a religious leader. They cannot ask you to quote, chapter and verse where it is you're finding the basis for your faith. But you can and should provide those because it gives sincerity to your ultimate claim. So let's say that you provide documentation for either a religious or medical accommodation to your employer. What is their responsibility? The law is very clear that your employer is required to take you seriously. They need to sit you down and engage in what they call an interactive process. Through that interactive process, they are seeking to determine if they can provide you with an accommodation that will both serve their business needs as well as your request for an exemption. What does that look like? It's going to be very different depending on you as the employee, what the accommodation is that you're requesting, and what the flexibility of the employer is depending on their type of business. Accommodations can be a wide variety of things. It could be masking, it could be testing, it could be teleworking, it could be social distancing. It's just really going to depend on what can your employer do. Now, if you request an accommodation that is wildly expensive or completely invalidates your ability to do your job, employers are not required to just give you the moon. In fact, if there is a serious impact to the employer's business, whether it be fiscally or operationally, they may not be required to give you the accommodation you are requesting. So bear that in mind. But what they are required to do is sit down with you at the table and discuss in good faith what your accommodation requests are and whether or not they can in fact provide them to you. In California, we have all types of employees. We have those that are at will in the private sector. We have those that are under employee contracts and unions in the public sector. Something specific that those in the public sector need to remember, and specifically for those of you that are employee association leaders. So far, the law is telling us that the ability to mandate vaccines is not something that you can negotiate. However, the impact to your employees, your members, and the working conditions are absolutely things that are not just should be negotiated, but employers are required to sit down at the bargaining table to meet and confer over. These can be things like where confidential information is going to be stored, how people are going to be tested, or if a vaccine mandate is required, how that's going to look like. How are they going to pay for it? Are you going to have to take time off? What if you get sick? Those are all important things that you need to be able to address and bring some conclusion and clarity to on behalf of your membership. While general advice is great, it's no substitute for guidance that is uniquely tailored to your personal life and situation. We understand that the guidance and the rules are changing almost daily, and it is a very confusing circumstance to find yourself in. Be sure that you consult with a skilled legal professional that can give you the guidance and advice that is best for you and your family.